her testimony that Susan Berman, in 1982, and made the damaging statements, which the court has already admitted, pursuant to forfeiture by wrongdoing. That is the first level of hearsay, Susan Berman and Miriam Barnes. During the cross-examination of Miriam Barnes, Mr. Lewis got up and his first question was, in essence, do you know how many words Mr. Lewin spoke during your interview? Do you know how many words you spoke during the interview? And made the implication that Miriam Barnes' testimony was a product of my interview with her. Now, tactically, it was not the smartest thing to do because obviously Miriam Barnes made the statement to, Susan Barnes made the statement to Miriam Barnes, and Miriam Barnes reported that statement back in 2000, shortly after 2000, early 2001, shortly after Susan Berman was murdered. So obviously, the idea that I could have put information into her mind 20 years before she said it, absurd.
The witness is impeached to some degree, and you're rehabilitating with a consistent statement. But Mr. Chesnoff says they're not actually consistent.
And on top of which, Your Honor, Ms. Barnes is going to testify. It's not as though she's unavailable. She's testifying.
Yeah, that
but
doesn't matter.
I still don't understand, Your Honor, under the definition of the rule, how this qualifies as a prior consistent statement.
So that would be the factual issue. Are these different statements? It seems like the essence sounds similar, but...
Yes, Your Honor, under 791, as the court is well familiar, I'm just going to read B, because B is what's appropriate here. An express or implied charge has been made that his testimony at the hearing is recently fabricated or is influenced by bias or other improper motive. And the statement was made before the bias, motive for fabrication, or other improper motive is alleged to have arisen. So, if I may pen, it's very simple. Miriam Barnes is going to testify to what Susan Berman told her. They have raised the issue that, in essence, it is incorrect, fabricated, influenced by improper motivations, etc. We are bringing in both, and in fact, Your Honor, that's not the only statement. The defense has already stipulated that Charles Bagley's interview with Miriam Barnes can also be introduced because that also is a prior consistent statement. Now, this becomes extremely important in this case, Your Honor, because Miriam Barnes' statements are the earliest statements regarding Susan Berman's cooperation. So in other words, we can demonstrate that those statements were made by Miriam Barnes in 2000, years before the Jinx, years before my involvement on the case, etc. And because the defense has alleged in their cross-examination of nearly every witness that these statements are the product of recent fabrication, etc., this is absolutely on point. This is exactly what prior consistent statements are supposed to be. Mr. Chesnoff cited Evidence Code Section 1235. That is prior inconsistent statement. That has nothing to do with this.
Your Honor, most respectfully, Your Honor, once again, this isn't about Mr. Lewin or attacks on him. What it is about, Your Honor, is the words are very clear. Evidence of a statement previously made by a witness that is consistent with his testimony at the hearing is inadmissible to support his credibility unless it is offered after, and then you go to B. It's Barnes that's the witness. It's not Greenhouse that's the witness whose statements are being challenged. I've never seen a clearer example, Your Honor, of double hearsay, not covered by an exception, and once again, Your Honor, all they're doing is bolstering testimony, most respectfully, Your Honor, that this guy Greenhouse doesn't come up with for 15 years later.
But you can bring that up.
I understand, but I want to understand, Your Honor, why it's a prior consistent statement, because neither myself nor anybody else over here understands it. And
well, you haven't given me the text of it, nor have you criticized, not of the statute.
I read you the text.
The text of the statement.
I read it to you when we started.
No,
okay, you had to compare the two statements. You haven't made an argument that the two are not actually saying that. You've argued it, but you haven't shown me how the... I don't have them in front of me. You read one statement, you didn't read the other statement, so how do I know?
Well, I'll make this, I'm happy to make a copy and you can have all of them, Your Honor, because Barnes says what she says, and then this man 15 years later gives multiple variations on what she said allegedly said to him back then, this is a lawyer, a reporter, never reported anything to any authority, and after 15 years, Mr. Lewin interviews him, and he doesn't provide one bit of percipient evidence. All he does is recite allegedly what Barnes said to him back then.
Which is what the code allows him to do.
Yeah,
So, submitted.
Yeah, I mean, it seems clear 791B unless they're different in meaning. I mean, you wouldn't expect exactly the same, but if it's essentially the same, it comes in under 791B.
And we're going to have the same issue with Mr. Bagley. They've already stipulated.
But Your Honor, he is not testifying of his own words. He is repeating the words allegedly said by somebody else. And if you look at B...
Wait. The words of Marion Barnes talking about what Susan Berman said to her.
Right.
Yeah, that's what this is for. This allows that.
An express or implied charge has been made that his testimony, Greenhouse, is recently fabricated or is influenced by bias.
No, that Barnes' testimony is fabricated, that Susan Berman didn't say that to her.
So then they're allowed to use Greenhouse to tell what Barnes said allegedly to him about what Susan Berman said?
Yes, right. Right.
I can't argue anymore.
Thank you, Your Honor.
Yeah, go on. Okay, let me know when they're here. Okay, thanks.